The law of self-defense content you are about to enjoy is presented for general educational purposes only. It does not constitute legal advice. If you are in need of legal advice, consult competent legal counsel in the relevant jurisdiction. Hey folks, welcome to today's Law of Self-Defense content. I am, of course, attorney Andrew Franco for Law of Self-Defense, and today I'd like to share with you my perspective on the most recent pretrial hearing for the Kyle Rittenhouse trial. That hearing took place this past Monday, October 25th, and lasted about 2.5 hours. As the headline to today's content suggests, the hearing was a very good day for the defense, with perhaps one glaring exception, one dropped opportunity, and yet another poor day for the prosecution. I'm sure you've all heard my pound the table legal adage, and that is, if the facts are on your side, you pound the facts. If the law is on your side, you pound the law. And if neither the facts nor law are on your side, you pound the table. And we continue to see little but pound the table out of this prosecution so far. To be more specific, this prosecution faces a considerable dilemma. Any objective and emotion-free view of the facts and law in this case can only result in the conclusion, to a reasonable degree of legal certainty, that it will not be possible for the state to disprove Kyle Rittenhouse's legal defense of self-defense beyond a reasonable doubt. For similar reasons, there is little basis, at least on the legal merits, to believe that the state can prove any of the recklessness charges against Kyle beyond a reasonable doubt. With respect to the gun charge, who knows what that statutory gun law stew actually means, apparently. Not even the judge in the case understands. So the charge should rightly be dismissed for vagueness, but at worst, it's a misdemeanor. So if this case were being judged on the legal merits, as it ought to be, there's little reason to believe that it could possibly result in anything but an acquittal on all charges, absent, of course, the possibility of a runaway jury, which is always a risk. Indeed, I expect the prosecution believes a runaway jury is his only hope for a conviction on any charge. If the prosecution has little foundation in legal merit, well, that's consistent with the case being brought for political reasons and not for reasons of justice, which in turn suggests the prosecutor leading this case, Assistant DA Thomas Binger, is pursuing the case for political and not legal reasons. And certainly some of his arguments seem to support that. And in pursuing his political prosecution of Kyle Rittenhouse, Assistant DA Binger faces considerable challenges. First, as already noted, he has neither the facts nor the law on his side, as I detailed in my legal analysis soon after the event itself. You can find that and all our Rittenhouse coverage at lawofselfdefense.com/Rittenhouse. That legal analysis was done on August 27th, 2020. They're listed in reverse chronological order, so the date should help you find it on that page, lawofselfdefense.com/Rittenhouse. So not having the facts in the law is obviously a huge problem for the prosecution. But second of all, opposing counsel here, attorneys Mark Richards and Corey Chirafisi, come across as extremely capable and savvy and unlikely to simply fumble the case for the state to run with. Third, Judge Bruce Schroeder, the trial judge, is a rigorously fair, old-school trial court judge and himself a former prosecutor who appears to lack any political interest in this case whatever, and most important, has little, if any, tolerance for theatrics and game playing in his courtroom. And that last is probably a fatal dilemma for Prosecutor Binger, because having neither facts nor law to work with, theatrics and game playing is about all that he has left. And that means he finds himself getting repeatedly smacked around and embarrassed in these pretrial hearings. If anybody is happy that this trial is finally scheduled to start this coming Monday, November 1st, it has to be Prosecutor Binger. He surely can't want to continue going through the pain and humiliating experiences these pretrial hearings have so often been for him. In particular, Binger is working desperately to try to have every fiber of context stripped away from Kyle Rittenhouse's use of force that night of August 25th, 2020, because the prosecution's entire case hinges on the notion that Kyle's use of force was unreasonable. The difficulty is that a key defining measure of what is reasonable for any conduct, it's always evaluated within the context of the surrounding circumstances, the totality of the circumstances. And the actual circumstances surrounding Kyle Rittenhouse the night of August 25th, 2020, manifestly make his use of force in self-defense and his alleged reckless conduct, other than that, reasonable under the circumstances. So, Prosecutor Binger is between a rock and a hard place. If the jury is allowed to hear the totality of the circumstances surrounding Kyle's use of force the night of August 25th, 2020, there seems no real prospect that he can convince the jury that he has disproven self-defense beyond a reasonable doubt, nor that Kyle's conduct was otherwise reckless beyond a reasonable doubt. It appears that Binger attempts to address this challenge in two ways. First, he tries to introduce irrelevant conduct, such as the video of Kyle's spoken statements, but no actual use of force, just spoken statements outside the CVS. Introduce that to degrade the clarity of the actual circumstances surrounding Kyle on that fateful night. The thinking seems to be along the lines that if you add one drop of poo to a barrel of otherwise pure water, now the whole barrel is poo water. Unfortunately for Binger, Judge Schroeder correctly excluded the various other acts evidence offered by Binger as either irrelevant or excessively prejudicial or both, so that did not work for Binger. Second, if Binger is unable to taint the actual circumstances of the night in question with irrelevant separate events, he's going to try to have those actual circumstances stripped out as evidence so that the jury never sees them. One example from this past Monday's hearing, the police that night told Kyle they appreciated what he was doing. That's an undisputed fact, caught on video. The video is going to be evidence. But this week, Binder fought to have that video excluded from evidence because he knows the effect that evidence will have on the jury to reinforce the perceived reasonableness of Kyle's conduct that night. Unfortunately for Binger, Judge Schroeder recognizes that reasonableness is based upon the totality of the circumstances and understands that the jury must be provided with evidence of those circumstances if they are to be able to evaluate reasonableness, the reasonableness that is a necessary core component of both Kyle's uses of force justification as well as a key negative element of the three recklessness charges Binger has brought against Kyle. Indeed, at times, Judge Schroeder's demeanor towards Binger's circus-like antics and ridiculous arguments were little short of contemptuous, as I'll show you. Now, I share all that as a preface, a top-level view, to provide you with a kind of broad framework in which to understand the events of this rather lengthy 2.5-hour hearing this past Monday. But with that framework in place, let's step through some of the highlights of the hearing in more detail. But before we jump into that, I do want to mention, of course, the sponsor of today's content. That is CCW Safe, a provider of legal service memberships, what many people mistakenly call self-defense insurance. What CCW Safe does is pay their members' legal expenses if the member is involved in a use of force event, and those expenses start big and get bigger fast, folks. If you've had to defend yourself or your family and killed someone in self-defense and are now looking at a manslaughter or murder charge, it's easy to burn through $200,000 pre-trial, folks. So unless you have that kind of money stuffed in a mattress, just in case you're compelled to defend yourself or your family, it can be helpful to have a partner standing behind you to provide the resources you need to fight that legal battle the way you want it fought, as if the rest of your life depended on it, because really it does. I've looked at all the companies that offer these kinds of services, as you might imagine, and I found that CCW Safe is by far the best fit for me. I'm personally a member. My wife, Emily, is personally a member. But whether they're the best fit for you is something only you can decide. Having said that, I do strongly encourage you to take a look at what they have to offer by pointing your browser to lawofselfdefense.com/CCWSafe. And if you do decide to become a member there, you can save 10% off your membership with the discount code LOSD10. That's LOSD for Law of Self-Defense and the number 10 at that URL, lawofselfdefense.com/CCWSafe. So the first issue I want to touch on that was raised in the hearing is Prosecutor Binder is attempting to have the testimony of a police officer, Officer Amanda Franco, excluded she's been called as a defense witness. And so one of the witnesses the defense plans to call on behalf of Kyle Rittenhouse is Kenosha police officer Amanda Franco. I don't know exactly what they plan to have her testify about. I think just the circumstances of the evening. But we can be assured that if the defense is calling her as a witness, their expectation is that her testimony will be favorable to Kyle. Obviously, otherwise, why call her? Prosecutor Binder knows this too, of course. So what to do? It turns out his answer was to attempt to use an extremely convoluted and not entirely rational basis to try to get Officer Franco excluded as a witness. And I mean extremely convoluted and not entirely rational. As some background here, one of the other acts evidence that Prosecutor Binger had sought unsuccessfully to inject into this trial involved an incident in which Kyle had come to the defense of his sister, who he saw engaged in a physical confrontation with another young woman. Binger wanted to introduce this evidence, there's video of this event, as evidence that Kyle had a vigilante-like attitude and a practice of injecting himself unnecessarily into other people's fights. The defense, particularly attorney Schroeders, argued against the admission of this evidence as being irrelevant to the facts of the case, too remote from the nature and facts of the case to be admissible. And Judge Schroeder agreed with the defense. So the defense won that argument. This was weeks ago now. The sister fight video, other acts evidence, was ordered excluded. Now it turns out that Officer Franco had responded to the scene of the sister fight and had encountered Kyle there, where they had a cordial conversation. It was because of that encounter that she would later recognize him again on the night of August 25th, 2020, in arson-lit Kenosha, where she would again have a cordial conversation with him. This past Monday in the hearing, Binger attempted to argue that she should be excluded, Officer Franco, as a witness to testify about the night of August 25th, 2020, because, he says, the defense had only called her as a witness in a backdoor attempt to introduce evidence about the sister fight. That's right. Binder is arguing that the same defense that successfully fought to exclude the evidence around the sister fight is now suddenly pulling a fast one to try to get evidence of the sister fight into the trial. Specifically, Binger argues that the defense was trying to relitigate, meaning to re-argue the issue of the sister fight evidence, but this time to get it into court rather than excluded from court. So I've embedded in the text version of today's content that argument, the video of that argument by Binder. If it doesn't make any sense to you, it doesn't make sense to anyone else either. When asked for a response, Attorney Schroeders dryly noted, and I'll quote here, "Judge, I would never relitigate a motion that I've won." Hearing this, Judge Schroeder literally laughed out loud. So I've embedded that laugh out loud moment in the text version of today's content too. But Schroeders did also provide a response in greater length. Binger further arguing that Franco's testimony should be excluded. That video's embedded as well. And when Binger realized he wasn't getting any traction with this line of argument, in his effort to get Franco excluded, he decided to try a different argument, that her testimony could not be relevant to Kyle's use of force decisions because she was not present at the precise moment that Kyle made those decisions. To this, the defense counter-argued that she was present in the general area throughout the night, had personal experience with the chaotic circumstances of that night, the same circumstances that the defense will argue makes Kyle's conduct that night reasonable and not reckless, and therefore her testimony is extremely relevant. Judge Schroeder didn't buy the prosecution argument as a good reason to simply exclude her testimony entirely. He conceded that if her testimony began to wander into inappropriate or irrelevant areas, he would sustain objections to those wanderings, but he was not inclined to simply preemptively exclude her testimony entirely, which is what the state asked for. Then Binger tried yet another argument. Now his position was that this offered testimony from Officer Franco was really just a backdoor attempt by the defense to put the Kenosha Police Department on trial and divert the jury's attention from the actual defendant, Kyle Rittenhouse. I've embedded the video of that argument by Binger in the text version of today's content as well. Defense attorney Tarafasi responded by essentially noting that it was prosecutor Binder who chose to charge Kyle with 3 counts of reckless conduct, and that the very jury instructions for recklessness tell the jury to consider the totality of the circumstances. And Officer Franco's testimony is, again, highly relevant to the totality of the circumstances. Video of that response embedded in the text version of today's content. Prosecutor Binger then suggests the defense is making an argument that they are not, in fact, making. Binder argues that allowing Officer Franco to testify how reasonable Kyle seemed when she encountered him earlier in the evening, to then suggest that he must have been acting reasonably when he shot 3 men later in the evening, is akin to a police officer telling a driver in the afternoon that he'd stop safely at an intersection, to later suggest that the driver was acting reasonably also when he ran over 3 people later that night. Indeed, if the defense were actually to make that argument, it likely would be objectionable to have Officer Franco testify for such a purpose. Just because Kyle was acting reasonably when she saw him doesn't mean he was necessarily acting reasonably later. But that's not the purpose for which her testimony is being offered. Rather, it's being offered as evidence of the generalized chaos in the area that evening, the area in which all the relevant interactions and confrontations occurred. Binger further argues that the location where Franco encountered Kyle that night was behind police lines and in a relatively safe area, and therefore did not reflect the circumstances as they existed in the more distant location, a few blocks distant, where Kyle is accused of having acted recklessly and have killed without justification. I've embedded Binder's argument on this point in the text version of today's content. Unfortunately, to Binder's horror, Judge Schroeder took this line of argument as an invitation to talk about the general state of lawlessness in Kenosha that night, asking, well, where was the law? And indeed, to compel Binder to talk about the general state of lawlessness in Kenosha that night. In a desperate effort to head off this line of discussion, Binder changes the argument again, now claiming that Officer Franco's testimony offered by the defense is really just a tricky way to suggest to the jury that Kyle had the approval of the police for his conduct that night, including the shooting of the 3 men and his alleged recklessness. This Binder argument, video of it embedded in the text version of today's content. Judge Schroeder recognizes that it would be impermissible for Officer Franco's testimony to be offered for the purpose of suggesting generalized police approval of Kyle, but that for the purpose the testimony was being offered by the defense, that arguably it went to Kyle's state of mind, even if only one officer said it and it didn't really represent the police, Kyle may have perceived it that way and it goes directly to his state of mind. That's certainly admissible and relevant. And again, that explanation is embedded in the text version of today's content. Now, as has become a familiar pattern, Binder then shifted to yet another argument, raising the issue that perhaps it was appropriate for Kyle to be armed and defending property where he encountered Officer Franco, so he looked reasonable there, but then he engaged in reckless conduct when he left that location and wandered into the chaos, acting outside his purview to protect a different location. But Judge Schroeder wasn't having any of this either. Instead, Judge Schroeder referred to the specific language of the jury instructions on reckless, noted that they told the jury to consider a wide variety of circumstances and that Officer Franco's testimony was likely admissible for that purpose. Of course, the judge reserved the right to sustain an objection of the testimony if it went beyond appropriate bounds while she was on the witness stand, but he denied Prosecutor Binder's motion to exclude Officer Franco's testimony entirely. So I'll count that as a win for the defense and a loss for the prosecution. The next major issue was the state's use of force expert witness, Robert Willis, who turned out to be a complete dud, and I think nobody was happier to see him go than the state itself. So he participated by Zoom. He wasn't physically present in the courtroom, but of course, the defense use of force expert did the same thing, Dr. Black. I'll embed the video of the portion of the hearing on Miss Willis in one large chunk at the end of this section, but it is about an hour long, so here I'll just briefly summarize my observations of this part of the hearing. Frankly, it was my sense that just about the last thing in the world Prosecutor Binder wanted to do was have Mr. Willis actually have to testify for the state on use of force issues. Unfortunately for Binder, he trapped himself into retaining Mr. Willis as an expert, believing it would be necessary to counter the defense use of expert Dr. Black. Now, the prospects that any genuine expert in use of force could look at the actual evidence in this case and conclude that Kyle's conduct was unreasonable under the circumstances is vanishingly small. And if they dared to try, they would be crucified on cross-examination by a well-informed defense. There was nothing about Mr. Willis's demeanor or testimony in this hearing that suggested to me the wiles to successfully push the prosecution narrative while subject to vigorous cross-examination. And I expect Prosecutor Binder was fully aware of this. Indeed, with Mr. Willis on Zoom, Prosecutor Binder did far less advocating for Willis as a use of force expert than he did continue to argue that he actually simply didn't believe that use of force experts were required at all. Of course, Judge Schroeder had already said that he found the value in the analysis of defense expert Dr. Black. So this line of arguing by Binder wasn't going to sell in this courtroom. Nevertheless, Binder tried to re-argue the no experts needed issue yet again, focusing on the claim that no expert looking at the same video that the jury would be shown would see anything that a normal juror couldn't see themselves. So why need the expert? In response to this no expert needed issue, the defense pointed out a great many technical types of analysis done by their expert, Dr. Black, that would not be obvious to a layperson. And Binder then seized the rhetorical life preserver that had been thrown to him, basically saying, hey, if Dr. Black was going to limit himself to technical analysis, that was fine with him. He just didn't want Dr. Black making conclusory statements that Kyle's use of force was lawful, as that was the ultimate question for the jury to decide. Of course, Judge Schroeder had long ago in prior hearings made clear that he wasn't going to allow any expert to make some pronouncement on a key issue in the case, like whether Kyle's use of force was lawful self-defense, period. So that possibility wasn't even on the table. Indeed, the defense announced in the hearing that they'd never intended to use Dr. Black for such conclusory purposes, but merely for his technical expertise. You could almost see and hear Prosecutor Binder sigh in relief at this path of escape from his own entrapment of having retained Robert Willis as a use of force expert. Binder informed the court that if the defense was only going to use their own expert, Dr. Black, as a technical expert, then he didn't feel he needed his own expert at all. And would the court mind very much if they didn't actually go through defense cross-examination of Dr. Willis today? Mr. Willis, I should say. And that's how the prosecution avoided what I would have expected to be a huge embarrassment. Indeed, the defense was frantically chomping at the bit to get at Mr. Willis on cross-examination. When Prosecutor Binder started reading through Willis's 60-some page CV, defense attorney Richards interrupted, said the defense was willing to stipulate to everything in the CV, accept it all as true without objection. But could we please just hurry up and move this along? They wanted to get to cross-examination pretty bad. And yeah, I laughed out loud when Richard said that. Even better, when the defense stepped through why Dr. Black's testimony would be relevant, they also took the opportunity to run through once again their evidence-supported narrative of how Kyle was repeatedly attacked and repeatedly compelled to defend himself, defend his life. So that's worth hearing again all by itself. And I've embedded below the video of the entire use of force expert witness exchange at last Monday's hearing. Amazingly, this line of conversation circled the bowl for nearly a full hour before finally being flushed, much to Prosecutor Binger's apparent relief. So that nearly hour-long video is embedded in the text version of today's content. So the bottom line here was ultimately the state withdrew its use of force expert witness, Willis, meaning that the only use of force expert the jury will now be hearing from is the defense use of force expert, Dr. Black. And I count that as another win for the defense and another loss for the prosecution. The next issue covered by the hearing was a state in limine motion asking Judge Schroeder to prohibit the defense from referring to Rosenbaum, Huber, and Grosskreutz as looters, rioters, and arsonists or other similar pejorative terms. Now, one of the rationales presented by Prosecutor Binger for this request was that, after all, Judge Schroeder had prohibited the state from referring to these men as victims, and therefore it was only fair that the defense be prohibited from referring to them by pejorative terms. These are not equivalencies at all, of course, but I'll come back to that in a moment. Ultimately, Judge Schroeder denied the state motion to prohibit the defense from referring to the three men using these pejoratives. Unfortunately, this denial has been widely reported as Judge Schroeder ruling that the defense has some kind of blanket license to refer to these men using those terms: rioting, looting, arsonist. That's not the case. In effect, Judge Schroeder simply said he's going to allow both parties to use whatever terms can be supported by the evidence. If there's evidence that any three of the men were engaged in looting, rioting, or arson, then Judge Schroeder will allow those terms to be used. But there must be such evidence in order to make the terms permissible. The defense does not have a blanket license to use such terms. First, they have to show some evidentiary foundation. Of course, the defense explicitly states they have the evidence needed for such foundation. Incidentally, Judge Schroeder also said that if the prosecution can show evidence that clearly indicates that Kyle committed the crime of murder in cold blood, he would allow the state to refer to Kyle as a cold-blooded killer, even over the objection of the defense. So the same standards being applied to both parties. And I've embedded that argument in the text version of today's content. And what about the judge's prohibition on the state using the term victim for the three men? Isn't he being hypocritical there? No, because the situations are not equivalent. The jury isn't being asked to decide beyond a reasonable doubt whether Rosenbaum, Huber, or Grosskreutz were looters, rioters, or arsonists. That's not the question before them. And because the jury isn't being asked to make those decisions, they are simply descriptors, not terms of legal consequence. The jury very much is, however, being asked to determine if Kyle's use of force against those men was lawful. If it was lawful, that necessarily means that it was Kyle who was actually the victim of the three men's unlawful force upon him, against which he lawfully defended himself. On the other hand, the state argues that Kyle's use of force was unlawful, in which case it would be the three men who were the victims of Kyle's use of force. The term victim then ties directly to the fundamental legal question that the jury is being asked to decide. And allowing its use to describe the three men would clearly be unfairly prejudicial to the defendant. Hence the prohibition by the judge. So that exchange, largely between Prosecutor Binger and Judge Schroeder, is also embedded in the text version of today's content. So having lost on this line of argument for prohibiting the use of the terms looters, rioters, and arsonists, Prosecutor Binder once again shifted to an independent rationale for the same requested prohibition. He argued that the conduct of the three men being described by these pejorative terms could not be relevant to Kyle's use of force unless Kyle had personally witnessed that conduct. And given that there was no evidence yet that he had, and unless he testified at trial, there wouldn't be any such evidence, that there was insufficient evidentiary foundation to make the men's rioting, looting, and arson conduct, even if it was demonstrably true, admissible as relevant evidence. Indeed, Binder argues these characteristics of the three men are only intended to disparage them, as if that alone justified Kyle shooting them. So Binder's argument on that point is also embedded in the text version of today's content. In response to that argument by the state, the defense once again argues that the three men's rioting, looting, and arson goes to the totality of the circumstances and should be admissible for that purpose on the same basis that Officer Franco's testimony of her experiences at the scene that night are also relevant. And that counter-argument by the defense is, of course, embedded in the text version of today's content. Judge Schroeder then accurately notes and cites Wisconsin Supreme Court case law that allows for the admissibility of the character or reputation evidence of the victim of a use of force, which is usually prohibited character evidence. In the case of self-defense, however, even if that person's character or reputation was not known to the defendant at the time he used force against that person. So in law, there are two grounds for offering this kind of character or reputation evidence in a self-defense case. Generally, of course, it's evidence of a violent character or reputation. The first rationale goes to the defendant's state of mind. I was scared of that person because I know them to be violent. Well, that would require that the defendant possess that knowledge at the time he used force. But the second ground for admitting this kind of evidence does not require that the defendant possess that knowledge at the time of the use of force, because for this second purpose, it's focused not on the defendant's state of mind, but on the state of mind of the person against whom the defendant used force. This second reason exists if the question of who was the initial aggressor is in dispute. In that case, that the purported victim had a violent character would be relevant to determining which of the parties was more likely to have been the initial aggressor. And this part of the discussion by Judge Schroeder is included in the text version of today's content. I did want to carve out one particular portion of this part of the hearing because it's so fascinating. It's only a couple of minutes long, but Prosecutor Binder actually argues to Judge Schroeder that there are no circumstances under which an armed man can lawfully shoot an unarmed man, period. That piece of video is also embedded in today's content. I encourage you to take a look at that. And frankly, I'll count this whole argument, especially that point, as another win for the defense and another loss for the state, because he couldn't be more wrong. Now, at this point, Prosecutor Binder rather goes off the rails by actually arguing that the question of who was the initial aggressor is not an element of the legal defense of self-defense. I know you don't believe me, so of course I'll include the relevant video of that in the text version of today's content. And yes, everyone in the courtroom was incredulous, and arguably even Judge Schroeder was outraged. Now, unfortunately, this leads us to the one spot of poor performance by the defense at this hearing, when the prosecutor argues that aggressor is not a core element of a claim of self-defense. Attorney Tarafasi responds to Prosecutor Binder's argument by circling back to reasonableness and saying that it's up to the jury to decide whether Kyle's use of deadly force was reasonable, and so who was the aggressor is relevant to that issue of reasonableness. In fact, who was the initial aggressor goes directly to the core element of innocence of a claim of self-defense, and it's a required element of self-defense always. Even states, for example, that legally presume many elements of self-defense in favor of the defender when the defender's in his home fighting off an intruder, they don't presume innocence. The prosecutor claims that the issue of the aggressor is merely a way to lose self-defense, but not to prove self-defense. In fact, it's just two sides of the same coin. A person who is the initial aggressor cannot claim self-defense. So the issue of aggressor is always relevant to self-defense. Well, almost always. And here was a real missed opportunity by the defense. The issue of who was the initial aggressor is always relevant unless the state is willing to concede the element of innocence to the defense and stipulate that it was the other party and not the defendant who was the initial aggressor. In this context, this would require Binder to concede that it was Rosenbaum, Huber, and Grosskreutz who were the initial unlawful aggressors in each instance. If he does that, he takes the element of innocence off the table, and who was the aggressor then is no longer an issue in the dispute. And the defense should have offered Prosecutor Binder the opportunity to do exactly that. You want to take aggressor issue off the table? Fine. Concede the element of innocence. Either the state agrees to concede the element of innocence and take aggression off the table as an issue in dispute, admit it was Rosenbaum, Huber, and Grosskreutz who were the aggressors, or the state refuses to concede the element of innocence and leaves aggression on the table as an issue in dispute and leaves the door open for the defense to admit evidence on the issue of aggressor. Folks, that's a win-win for the defense either way. But they apparently failed to spot the opportunity. Now, after the defense counter-argument, Prosecutor Binder goes back and forth with the judge for some time. So this next video clip is a little longer than most, but we do have the video of that argument embedded in the text version of today's content. In any case, Judge Schroeder clearly finds that the question of initial aggressor is an issue in self-defense and will allow relevant evidence on this issue. So although the defense missed an opportunity, I think, they did win on the ultimate issue. So I'll count that as another win for the defense and another loss for the state. Now, I did want to highlight the last couple of moments of that last clip because it is so laughable. And here we actually see Prosecutor Binder attempt to argue to Judge Schroeder that arson is no big deal. It's just a bunch of kids being loud and disorderly. Judge Schroeder actually responds to Binder, and this is a quote, "I can't believe some of the things you're saying." After going back and forth on this for a couple of minutes, Judge Schroeder simply dismisses Binder as one might dismiss an ex-spouse, effectively saying, listen, is there anything else we need to talk about? It's actually pretty funny. And that short clip, of course, is embedded in the text version of today's content. And I'm going to go ahead and count this as another win for the defense and another loss for the state. Next, the state asked Judge Schroeder to prohibit the defense from mentioning to the jury that the families of Rosenbaum and Huber and that Grosskreutz himself all had active civil lawsuits seeking damages from various parties over the losses the night of August 25th, 2020. The defense wants to reserve the right to mention these lawsuits if any of those family of the two dead men take the stand to testify, or if Grosskreutz himself takes the stand, because their civil suits go to bias. If Rittenhouse is convicted, they essentially win their lawsuits automatically, so they have an incentive to lie. Judge Schroeder ruled that the defense would be allowed to introduce evidence of the civil suits for that limited purpose under those specific conditions. I've embedded that video in the text version of today's content, and that's another win for the defense and another loss for the state. Finally, the state asked the judge to prohibit the defense from referring to their client as Kyle and to require everyone to be referenced in a formal manner, such as Mr. Rittenhouse, Mr. Grosskreutz, and so forth. The concern of the state, of course, is that referring to Kyle as Kyle may remind the jury of his youth. After all, he was legally a child on the date in question and might garner him sympathy from the jury. The response from Judge Schroeder was that he was indeed going to require that everyone be referenced in the formal manner, except for allowing the defense to refer to Kyle as Kyle. The rationale for the exception is that he does not expect a lawyer, given the close relationship with the client, to only refer to the client in a formal manner. Therefore, the defense will be permitted to refer to Kyle as Kyle in front of the jury. And that ruling is also video embedded in the text version of today's content. And of course, it's another win for the defense and another loss for the state. And I'm not going to add up the score, folks. You can do that if you like. But the final score in any case was 100% of the wins for the defense and 100% of the losses for the state. That's not a great day for the state for sure. Okay, folks, that's all I have for you on this topic at the moment. Remember, if you carry a gun so you're hard to kill, that's why I carry a gun so I'm hard to kill, my family is hard to kill, then you also owe it to yourself and your family to make sure you know the law so you're hard to convict. Until next time, I remain Attorney Andrew Branca for Law of Self-Defense. Stay safe.